Good morning, United Kingdom. Good morning, everybody. And welcome to 8 a.m. to 9 a.m. drive time session with Lakhi Singh, the property fixer. Good morning, Lakhi Singh. What's the weather like there in the United Kingdom?
The weather is nice and rainy, but I like it. Tiny bit overcast. So it's absolutely wonderful.
Right, okay. So the topic for this week, we continue, is invest in the future, grind now and smile later. That's the week topic, or the saying of the week. Topic today is, can Lakhi Singh stop a repossession even after the court gives an order for it? It's a clever question. It's all about Lakhi Singh helping people to get out of their issues. But before we go into that topic, I'm going to try and keep the topic more focused on live events. Tomorrow is going to be the last debate between Mr. Trump and his rival. What do you have to say? Do you think Mr. Trump's going to win? Where do you think it's going? Is it the Democrats or the Republicans? Who are you in for?
I don't really know much about US politics, but I would say that my bad guess is Donald Trump. He's got a lot more PR, and he's a born salesman. So he'll pull every trick out of the bag to actually win. So he doesn't really like losing, and so let's see.
Okay, so we've got from Bob Singh to you, the property fixer, signed this morning. Good morning to you, Bob Singh, bright and early, sharp as an eagle, dealing with all those applications for mortgages, this busy time of the year, trying to get people into their dwelling, to their homes. Bob Singh, yes, Lakhi. So you're not much into politics, but surely someone who is as versatile as Lakhi Singh, the property fixer, being it that you are like the mirror of Superman in United Kingdom, surely you must talk to Superman sometimes on the phone or Spider-Man and ask him what's happening in your neck of the woods. Surely if America sneezes, the world catches a cold. Is this not a global economy? Why is it you don't have an understanding of American politics? What would Spider-Man say about Lakhi Singh, the property fixer, the Superman of the square mile, the mover, the hoover, the shoover, the fixer, the ixer, the maker, the breaker?
Yep, so let's move on. What's the next question?
Yeah, okay. So how is it you can stop repossessions even after the court has ordered it? It's quite, because we were talking, I think, with the wonderful Deborah, I think, yesterday, and she possibly hinted to taking in a bath towel and using special oils to calm down the judge. But I'm not sure that would work, and I'm not sure they would allow them to lie on the court tables and be massaged. So what is it you're doing that's going to change the judge's decision even after he's ordered that a property to be repossessed?
Okay, so as an organization, we specialize in helping people to stop repossession. So I think we've probably saved over 5,000 people from actually being repossessed in the last 14, 15 years or so. So first of all, I'd like to add that we certainly have the experience of knowing what to do. Secondly, I'd like to add that there are a lot of organizations out there that provide support in helping people, such as the Citizens Advice Bureau, Shelter, but they have they're very linear and they're not really sophisticated in understanding complex property portfolios or complex situations. So they'll just tell you the bog standard thing that you just can read on the internet, go in and come up with a payment plan and show your income expenses. So they'll tell you all the things that you need to do, which is what the bank will tell you anyway, which is when you talk to them, they'll tell you what to do. So they'll pretty much tell you to really fall on your sword in some ways. Because
this is more like a samurai versus the system. So you're a bit like a samurai when you go into the court, and you will fall on your sword in case you have been dishonest.
That sort of thing. So the point is that a lot of these organizations that are meant to be helping you, they've got limited knowledge and expertise in terms of understanding the problem around repossession. Once in a while, you might get an odd nugget where you might find somebody who really knows their stuff back to front in a citizen and come up with a solution. But on the whole, the knowledge is limited. So just wanted to pre-warn people out there that all is not as it seems. You're not really going to necessarily get a guaranteed way out of the problem. So then the question is, how do you get out of repossession, and what are the, how
that's the question. How then, Lakhi Singh?
So that's a sort of couple of background for everybody to know. Now, some of the critical things that can be done, some of the 4 or 5 simple things that can be done. Number one is we offer a free consultation, and we will look through all the information you've got to find out really what's happened so far, because you can actually, if you know what you're doing, there's a possibility you may be able to extend the potential repossession to another 6 months or 12 months to buy yourself time to find a solution. So the first thing we look at is really, is there a way of litigating with the bank to stop the repossession? Now, before we go into repossessions, there are 2 different types of repossession that can occur. Well, in this case, when we're talking about a verdict or an order from the court, it relates to a homeowner, just to make it clear. Can you hear me okay? You seem to have frozen. Okay, so let me continue. So the first thing is that you need to get something called an N244 in if a repossession has actually been ordered. And in that N244 is you need to have some sort of solution that's going to get the judge to agree to stop the. So the first, so I think you cut out, but the first thing you need to do is get an N244 ready. I think you seem to cut your back.
Yes. I'm using my superpowers to get us connected.
Okay, so I was just saying that you need to get an N244 once an order's been given by the court. And that N244 is going to be critical in terms of knowing what you need to fill in there to potentially stop repossession. Now,
N244, is that a person in the court, somebody who's going to turn up and is going to help the client talk to the judge and convince him? Is it a superpower, N244, like Spider-Man or like Superman or like the fixer that will convince the judge? What is N244?
So the N244 document that is used to communicate to the courts to tell them that you have an alternative way of stopping the repossession, and they should actually take it seriously, so they can actually have a hearing whereby they will then listen to your plea as to why they should actually not continue with the eviction. Now, there are a few different things that can go into that form. Number one is if you were unemployed, you may have found a job. That could be the big difference, and you may not have had that job at the time of the verdict. Number two, it could be as simple as you found a finance solution, and you want to present the finance solution to the courts, and you got full validation of what's going on with that. So you will need to present that. Number three is you put the property up for sale, which you didn't do before, and you've found a buyer, or you've got confirmations of that. So these are three simple things that could make the difference in stopping the repossession, and they could make all the difference in getting your property back. Other things are that you may have realized that you may not have presented certain information in court, such as that you've got 5 young children below the age of 16, and they've got local schooling, and if you didn't have that property, you weren't there, or you've got a number 5 could be that you've got somebody who's let's say very ill, and then they need care from social services. It could be an elderly parent. It could be a vulnerable teenager. It could be any number of these type of things that will mean that there's a social requirement for the court to not really be evicting you. So all what's happened is, in the time of the verdict and the eviction, can be anything from 2 weeks going up to 56 days. And in that time, if circumstances change which are going to be beneficial for the court to realize that they shouldn't be evicting you, then we would go through quite a detailed questionnaire checklist to work out what would be the most beneficial type of things to present on an N244 to the courts, and when to present it as well. All of these things, the nuances of how some of these things are done, will make all that difference.
Excellent. We've got a good morning from John Smith, from Sonia, and from Rachel as well, who says, thank you for setting the morning powder, for giving her, obviously the powder being some super powers that she uses, like the property fixer, the Ixer, the gentleman who is the Superman, the hero of the square mile in London. Yes. Okay. So there's a lot of different varieties of reasons, you're saying, Lakhi Singh, that not even Citizens Advice or Shelter and these other organizations are aware of, that the courts will consider or reconsider the repossession of a property. Is that what you're saying, Lakhi? And it's because we think out of the box, because you are a Superman and you can spring outside of a box with different reasons, and you will use those reasons to stop the judge, or at least delay the judge from a repossession. But the question I'm going to pose to you then, on behalf of us mere mortals, and that is, if we don't have the finances, and one of the reasons that we're being repossessed is we've lost our job because of the virus, or because our company has now closed down because they put us on a furlough and now they've decided to close down. How do we then use your superpowers of reasoning, the fixer, with the judge to convince the judge to stop the repossession? What ultimately is it that we need? Is it finances? And do we need the monies to be able to negotiate with the court? Because without the money, there is no negotiation.
Well, to be honest, whatever situation is presented, working out which argument we believe would be the best one to get either an extension or to stop the eviction altogether is not really like a one-off answer I'm going to give on the show here, because everything comes down to circumstantial, what's been presented first time round. I mean, had somebody presented that already in the first instance, and the verdict's been given and the order's been given already, that's obviously going to play a big part in deciding really whether you're going to put that in again or not. So I think everything comes down to a detailed analysis, understanding the exact circumstances by which things have led up to the point of the order, and anything that's happened post the order, and any other, let's just say, things that have been put in the order for us to understand really what the angle is. Because sometimes, okay, I think at least about 40 occasions I've had clients and they said, I've got an eviction, but they just at the very last minute, they've told me it's a suspended possession order. And for those of you who don't know what a suspended possession order is, it means that they've already been to court at least once in the past, and the court has actually allowed them to stay in the property, but on the condition, it's a conditional verdict or an order to say that if they miss any of their repayments, which are above and beyond the payments at the time to pay off the arrears, then the property can be taken back, and an eviction will take place. So once they've broken that, then the likelihood is that that's a different type of order for possession than compared to just a normal order for repossession. So that's called a suspended possession order.
Okay.
So a lot of people get confused about what they've got, because they've got their head buried in the sand. They don't really want to be thinking about all the technicalities. They just want to save their property. So, but the devil is in the detail.
Okay. So I understand repossession, and then you have these other things which are built on top, and obviously courts have to operate. Is it true they say that that most of the court, or the system, I would say, it's probably broader than that, is bank facing? So you're already on an uphill struggle if you're trying to deal with the repossession, and you've gotten an order against you for repossession. That is quite difficult for you to get out of that, because the banks are in control of everything, and the system actually revolves around what the banks want, and the banks are, they say, are the first chargees of the property normally. So is that also another reason why people find it very difficult to deal with the court? But you're obviously experiencing that, and that's why you suggest that, they should come to you for your support and help and your advice in dealing with repossession because you understand the nature of the beast as well. I would, if you want to use that word. Yes. What do you have to say to that?
The nature of the what, sorry?
The nature of the beast. You understand the nature of the beast, the way the organization, the way the system works. And because people don't understand it, they actually don't seem to realize that, in certain cases, the bank will have it every which way but lose. And that's quite difficult.
Yeah, I think what a lot of people don't realize, I understand the point that you're asking about, which is a lot of people have a very rosy picture of the government and the banks and the court system. So they almost have a automatic assumption. I mean, not talking about everybody, but the majority of people have an automatic assumption is that the court and the bank are going to be quite cuddly. They're going to be quite nice to them, and everything will be all right. To be honest, making presumptions is the mother of all problems. So if you presume anything like that, the likelihood is that you're not going to have thought about the risks and not covered them off properly. So when it comes to saving your property, you have to be very comprehensive in your understanding of the problem. And now it's not just the banks that are not necessarily actually the issue. You got quite a few different obstacles to contend with. So let's just go through them all. So number one is you're going to, when you're talking to the bank, you're not going to be talking to the bank. You're going to be talking to a junior administrator who's a number cruncher or just somebody on the phone. So they're not really going to be savvy about repossession, and they're going to, you're not really going to understand really what the implications are when you're setting up payment plans with the bank, because they're not really going to be, they're going to say things like your property is likely to, you may end up going to court, blah, 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 but you may not understand the gravity of what they're saying and doing. I remember I've actually been through this situation personally when I had issues about 15 years ago. So I understand the nuances of this. So number one, you're dealing with junior people in the bank. Number two, you're dealing with the court systems that's quite archaic, and they will, if you get your paperwork wrong, or you put the wrong paperwork in, or you put it in at the wrong time, you may find a small mistake could actually be the loss of £1 million property. You could actually literally lose your property because
just because of a grammatical error, one full stop, and you lost £1 million. Very drastic.
Yeah, I mean, if you submit your documentation and then lose it, then and if they haven't got it, or you haven't checked that they received it, and you assume that they've got everything, then the court, you don't hear from them at the court hearing. You don't turn up thinking, because I've had a situation before myself where I couldn't turn up to court myself. I had a court hearing regarding a particular property for one of my own properties, and I actually broken my Achilles, so I couldn't really walk, and I was on medication at the time. It was quite leading up to it, and they didn't receive the documentation. But then the property was repossessed, or the order was given for the repossession. Then I had to go back in to actually put an N244 in, exactly what we're discussing. So number two is never really trust the court system to be efficient in terms of what you want done. You need to do, you need to probably be on the phone for a couple of hours, because the courts are notorious for actually being very slow in their communication and correspondence, especially now with COVID-19. So that's the second thing I would say, just be really wary of.
Yeah.
Third is another sort of like a glitch is bailiffs. So even if an eviction order is given, a lot of people don't know this, but this is a bit of a nugget for anybody who's facing any of these type of issues. If you've got a bank that's very aggressive, combined with a court that's got bailiffs that are quite quick, they can actually speed track the eviction.
Okay,
So
right.
Most, especially with a suspended possession order, I've known banks to take possession within 7 days because they've realized that they can't, if the bank leaves it too long, the client's already had a suspended possession order, they've been to court 5 times, they want to come in with stealth. They're not really going to hold any hostages. They're not really worried about you and your family and your children and your job or whatever you're doing. They just want their property back. So
you're saying a suspend. You've mentioned this terminology about 2 or 3 times this morning. Suspended possession order. What does that mean? Does it mean like there's an order that's flying around in the air and everyone's trying to catch it, and it's only Superman who can catch it because it's too far up in the air, suspended? What does that mean?
So suspended possession order is they won't possess, but they'll leave it and possess another day if you don't keep up with whatever's been agreed in court in terms of a payment plan. So I'll give you a specific example. Client goes to court, comes up with a payment plan. The court says, oh, well, we're not happy that you haven't paid your arrears off, but looks like your circumstances, looks like you're going to get a job in a couple of weeks because you got the contract, but you haven't kept up the payments. So if you can keep up the payments and pay off the arrears in the next 2 years, we're going to add on an extra, let's say £500 per month until that pays off your £12,000 worth of arrears over 2 years. And let's just say that gets put in the order, gets sent out to you, receive that. So basically, let's just say after 3 months, the bank doesn't receive your £500 for you for the 3rd month. It could just be that you had a problem with the bank or whatever, and then you haven't checked, and the bank sort of writes to you, and you ignore the letter. You just think it's gone through. At that point, when they haven't received the money on time on the date, the bank is pretty much can go to the bailiffs in the court and say, well, we haven't received the money, so we need to now repossess the property. So then, so that's what I was talking about, that the bank can act with stealth and you won't really know. So you've got to be very careful, because once you're in a suspended possession order, it's a slippery slope. It's very difficult to come back out and once move. And basically, it's you haven't really got a chance of keeping your property. Yeah.
Okay. I'm trying to work out then. Okay, you've got people who are obviously keeping up their mortgage payments. Does the judge look at negative equity as a reason to grant a repossession? So can you look at the fact that you've got a property and you've got outstanding £500,000 mortgage, it's only worth 400,000. Well, could that be a reason for the court, for the judge, just to say, forget about anything else? You're owing more than the property is worth, and I'm just going to take it back. Can that be a reason for the repossession order?
It's a very good question. My best answer to that is that anything can happen with any judge at any time in any place around the country, and there's no consistency. Just remember, there's no consistency in court. The court is based upon how the judge feels in that morning. If he or she's had an argument with their spouse the night before, when they wake up, they come into court, they could actually decide whatever. There isn't really a precedence to say that they're going to, repossess your property because it's a negative equity. But I'll give you a sort of practical answer to that question. Number one, if you're a negative equity, but you're keeping up your payments and you're consistently keeping up the payments, then it's going to be very difficult for the judge to be ordering an eviction, a repossession, because the court's going to be thinking, well, this person's actually trying their best to keep up with the payments and they haven't done anything wrong. So that's one thing in your favor. The second thing in your favor can be is that if negative equities occurred, and you're in a good area, or you're near a school, and you've got young kids, you've got 4 or 5 different things which are in your favor, because they don't really want people to really go on to the streets. It's going to clog up the whole welfare system. So there's a bit of a balance. If you've got a reasonable judge there, they're going to say, okay, well, maybe a negative equity, but this client's in hardship. Let's try to help them to try and keep them afloat. So this is sort of being very nicey positive about the court system. Now, the other way of looking at the whole problem is that if somebody is in negative equity, the bank have got certain stipulations in their contracts, and if they're to bring them up, there's a strong possibility if they presented them to the judge may deem whatever is being brought out as favorable for the bank, because they may argue there's certain clauses in there that if the property does fall below by 10 or 20% from the debt amount in terms of value, then the property equity in the property is going to be brought back up. So there is a possibility that the court could order that you've got to bring up the amount of equity that's got to go back into the property to actually make it go above the debt amount. Now, I've seen documents from a couple of banks, including Santander in the past, where they've said they've actually written to clients who've got negative equity, asking them to bring it up. But I haven't really seen it as a court matter in terms of a house that's in repossession, where the negative equities become a problem if the person owning the property is actually keeping their payments up.
Okay. So you're saying the court environment is a bit like a driving instructor. It's all on the day. It could go good, it could become bad for you, but you have the magic formula because you're the property fixer to look through everybody's clothes and see what's under the files. Is that what you're saying? Your X-ray vision.
Well, the advantage I've got is being the property fixer. It's not just me. I've got a team of people around me. So we work with 200 solicitors around the country who we actually prepare the bundle and give it to them to actually attend court. We've got in-house expertise on any type of repossession, insolvency, IVA type matter. but because of the way we're structured, we have a lot more ability to not only fight the battle for our clients, but also to win the war. A lot of law firms and insolvency practices, they're quite good at fighting the battle and maybe winning a battle, I would say, but they don't know always how to win the war. Now, what do I mean by that? What I mean by that is that the client net result that they want of everything they need done is sometimes can only be done by a consultancy or a structure like ours. Whereas if you're actually caught in the system, because if you are an insolvency practitioner, you're governed by certain rules. And if you are a solicitor and you are in litigation, even then you've got to follow certain protocols. You're almost like you got almost have a conflict of interest in some ways, because if you really think about it, I mean, this is going to sound a bit sort of over the top for people. If you're quite a large law firm, you working with every single bank and bridging company and providing Buytolet conveyancing, all of a sudden, if you've also got a repossession arm, you're already in the bed with banks, and when you go to court, the same bank that you're lending money for and acting as a conveyancer, you're meeting them again in court for a property to actually stop a repossession. So your hands are tied, because you can't really be dipping in one bit and then also dipping in the other, because financially you already have a self-interest as an organization. So I think any law firm out there, especially if they're in the top 50 or top 100, it's unlikely that you're going to get a favorable result. The chances are going to be, let's just say on paper, maybe 95%, but practicality, it may be more like a 50-50, because there's a conflict of interest there. So that would be my concern if I was a client looking to actually stop repossession from a bank coming after me for my house. Okay.
So we're learning more the deeper we get into this topic. That really, it's a very tricky type of an environment where all parties, or almost all parties, are facing the same direction. So where do you see this aspect of repossession going? Do you think there's going to have to be a revision on how repossession takes place? It's going to have to be something that changes, because if it's also draconian, it's all based upon a mood swing, and whether the judge has had a domestic in the morning, or it's had some bad news. How do you counter that? Could it be AI? Is that the right way forward? Artificial intelligence? Is that what could become a very sort of consistent in providing outcomes for court cases? Would that be the way to handle it, or what?
I think that's certainly a good idea. But the thing is, it all depends on which side of the fence you're sitting on. If you're sitting on the bank side of the fence, or if you're sitting on the client side of the fence, it's open to manipulation, because it's a bit like Google. I'm not sure if people are aware that they're a monopoly. So anything that you're putting in there, there's a variance of potentially 10 to 30%, more or less, in terms of information you're getting out or information that's being withheld regarding elections for the America, for example, or even in the UK. So the AI and
talking about the
algorithm.
elections in the US.
That's right.
Bob Singh obviously says Biden is ahead in the polls. So what you're saying is that subject to manipulation? Could that be changed? Is that true? Is that a correct result?
Yeah, it's subject to manipulation. Anything subject to manipulation, this all comes down to the sort of, how do you say, the level of control and who's controlling what. So, I mean, the AI is quite a sort of, it's a good question, but it takes us away from the point about how do we help people out of this particular issue. My view on it is that what I think should happen is that there should be like £100 million fund, which gets given to Lakhi Singh, the property fixer. In fact, I've had at least a couple of organizations who are happy to give me potentially £1 million to £5 million, which I'm in early negotiations with, or I've planted the seed. So where we can go into court and have the ability to provide more support to people so they don't go out on the street.
Well, we've got Bam Wise, I think, who's on.
Sorry?
We've got Bam Wise on YouTube who's saying excellent advice. Is there any use in using licenses over ASTs, I believe? That's the question he's posing. Can a license help once you're talking about repossessions over an AST? So I'm not sure where the question's coming from, but
So I think the topic there is probably relates more to buy-to-let properties, because ASTs are going to be for people for tenants that may be getting evicted from a property. So I think there is a room. I mean, that's a different topic altogether. So I don't know if you want to discuss that in detail, but in simple terms, just put that one to bed is that licensing for longer ASTs could actually be more helpful in stopping repossession, stopping eviction for tenants that are living in a buy-to-let property. But I'll say I'll just draw a line to that one for the moment, so we don't get distracted. Main topic.
Okay. Yeah. Okay. So you were saying something about
so basically
and him being ahead and the manipulation of information.
So I've got a couple of organizations which have got access to funds. So if we really wanted to help, which I'm pretty keen on doing, it'd be great to have a help slush fund that can be used. It's a bit like it's called micro lending in Africa, where people get given money, they get lent it until the time that their business becomes sustainable. So the similar sort of principle, something I've never really discussed on the show before, but similar sort of principle whereby we have access to funds. So when we go in, we have 5 solutions, a bit like the COVID-19 pandemic, sort of like a medium, high, and very high type of solution. Very high would be that we can pay off their debt altogether for their mortgage, and they have a friendly bank that looks after their mortgage until the point they can pay it all off. So they don't have anybody breathing down their neck, but they still have to get it paid off. But we might help them to subsidize it or reduce it by 50% to make their life easier, because we've got a social check on their problem rather than a bank check. A bank checking it's going to be looking at how do they make their profit. We were looking at it from a point of view, how do we help them sustain their livelihood? How do we help them to ensure that those that are vulnerable in their family, they've got 5 young children, they've got vulnerable adult living at home, or somebody who's got needs home help. So, I think it's very important that we don't forget the humanity in these type of issues that are there, but they're too easily forgotten in a very commercially led banking system, and the courts most of the time actually following the banks, sort of jumping to the banks sort of beat, rather than looking at the client's problem. So we have to be careful that we're not negative towards courts, but on the whole, the banks actually do have a lot of clout, because they're the ones that are holding the contracts. Most people don't even read their contracts, don't even know there's a contract that they're beholden to on the day that they've actually taken out their mortgage. So if everybody was to read their small print on day one, there'd be a different.
Right. So you're saying the contract's important if you're being repossessed, is that right?
Yeah, I think if everybody knew really how tight the contracts are when they buy an asset to live in, they may have a different thinking process about actually buying something. They may just prefer to rent if they knew that it was that draconian. So I think everybody should read their full contract end to end. And if anything, I think we should actually even literally get the contract ourselves here, pull out all the draconian clauses so people know what they are. And we need to, it's our job, the property sector, to actually to clearly communicate the potential issues that could come and bite people on the bum if they don't listen.
That probably sounds like an interesting idea, because I think a lot of people who own personal house, and okay, we're talking about repossession, and I assume repossession only applies to your residence. It doesn't apply to buy-to-lets, does it, Lakhi, or does it?
The laws for buy-to-let are different, but they are even more draconian than the laws that you have for a residential homeowner. So I think we could also cover that as a separate topic, because regulation, the approach, the structure, but around that type of repossession, they're calling it LPA receivers, but it is actually a different. It's just the same thing with a different title. So LPA receivers is just commercial. It's just a commercial repossession. That's the only difference.
A commercial repossession, right? Okay.
So LPA receivers are appointed by banks if you are in arrears or in default, or you don't pay your mortgage for your buy-to-let. So they can literally do that at a drop of a hat. So there's actually not much of a discussion about what you can do with that. But again, we are very, very comprehensive in dealing with LPA receivers as well. Having, like I told you, dealt with over 5,000 repossession matters, both commercial and residential, across the whole country over the last 12 to 14 years or so.
Yeah. Okay, so what you're saying is there's a different structure around the LPA Act, but that's a commercial repossession. And you're talking about repossession that happens at court. And is the repossession that happens at court only to do with residential assets? So if the entire structure is, geared around a very aggressive way of the banks dealing with, what are the reasons that you can be made repossessed? What are the reasons that the banks can take you to court to apply for a repossession order? What are those? Can we understand what those reasons are? What type of common mistakes do homeowners make that lead to repossession?
Okay, so the most common ones, most commonly known one is where people have lost their job and they can no longer pay their mortgage, or they can only make part payment. And what happens is there is a solution to that as well, which is that some people know that they're about to lose their job, so they ring up the bank, and they have been people in a position which certain banks have been able to get a 6-month mortgage holiday, or a 3-month mortgage holiday. That certainly helps them. So the first one is losing your job and getting into arrears. The second, the others are a lot more, let's just say, mixed in terms of what they could be. So if you've done something, for example, it was a buy-to-let mortgage and it's a residential, is actually, but you're living in the property, that you're breaking the conditions of the buy-to-let, but you're trying to make it residential. So there's
conditions. What conditions are you talking about? The terms and the conditions? The contract? What are you talking about?
Talking about the terms of the contract. So any terms that are broken. So other ones off the top of my head would be things like you're living in a contract that's a buy-to-let property, but you've actually living in a buy-to-let property, but you're now sort of, it's technically become residential. So there's a few issues around that. So the bank has to now repossess you because you're living in a property. So there's a whole lot of different legislation and laws around really what would happen there. You know, so that's one off the top of my head. Another one is, let's just say that you haven't followed certain protocols in terms of things that you were meant to do when you bought the property. On the buyer's report, if you've had a detailed structural report, you were meant to do certain works on the property to maybe cover any insurance risk or fire risk. You haven't done those sort of things. That could actually be something that's an issue for the bank, and they write to you and say, by the way, you were meant to get rid of the asbestos, or there's a fire risk in terms of the type of cladding the property had, and you haven't actually met with that stipulation, so you're putting the property at risk, and if something happens, we're the ones that actually got the risk, not you, because we're the ones that are giving you the lending. So it's going to be things like that which break any conditions that you have in the contract. It could be something quite nominal, but yet it could be significant from a bank's point of view. So they could actually take you to court and threaten repossession to enforce whatever they want you to do that you haven't done. Yeah. I think those are the sort of simple things I can think of, but it's primarily people getting into arrears and not being able to keep up the mortgage, the main ones I can think of.
Okay, so is there any way to that you in your in the deep experiences that you have with the team that you employ, etc., are there any techniques or avenues or approaches that protect the landlord, or not the landlord, but the mortgagor, the person who owns a property, indefinitely from the bank? Because it seems like the bank has a lot of controls in trying to take repossession of the property, and it could be a reoccurring nightmare. You say suspended repossessions. So suspended repossession means they said yes, but we'll give you more time. So what's the period on a suspended repossession to be effective? Because even a suspended repossession, I think, maybe has some time until it's valid, and then after that it becomes invalid. Is that right?
Yeah, what happens is once you made your full payments, described earlier, 2-year payment plan, then once well, it all depends on the order. I mean, if the court says that after 2 years of making the arrears payment, you're up to date, and for another year, if you actually go into arrears again, then technically you are still on a suspended possession order. So there isn't really like a set formula for suspended possession orders. It could be dependent on the judge on the day. But the standard format is that obviously if you made your repayments, after that, you're in the clear. And if you were to be late again in your payments after that, the likelihood is that the bank will have to follow the normal process of taking you to court again for a repossession hearing.
So you're saying is it 2 years, is it? Suspended
it can be anything from 2 years to 5 years or longer, depending on how the...
So does it fall into the... Does a suspended order fall into the Limitations Act? So is it not under the 6-year period? So if you had a suspended hearing and up until 6 years, the suspended hearing can be re-invoked and they can go back into court and ask for the repossession? Or is it a 2-year thing or a 5-year thing? Does it fall into the Limitations Act?
I don't know about that, to be honest. I'd have to check with our legal team, because the Limitation Act, I think, probably is, I don't think actually has an effect on court orders, because it's actually decided by a judge. So in terms of how they want to instruct you in terms of what you've got to do. So I think that's more if you owe money to a bank because there's a shortfall, then I think they've got up to 12 years to come after you for it. So I think the Limitations Act may be more pursuant of debts that you owe as opposed to a court order.
Okay, right. So court orders, you're saying, suspended orders, they are not subject to any Limitations Act, and they're probably
I think we can check with our legal expert, and I can come back to you tomorrow.
Okay, that sounds like an interesting question. We need to further. We're in the last 2 or 3 minutes of our time. Mr. Noor obviously is giving us a shout out, saying excellent topic. Mr. Noor there in the commercial department at MC4U, making moves as usual. So get it right, Lakhi. I mean, I've listened to you this morning, and it seems like there aren't many people out there, not even law firms out there, that know how to deal with the system in trying to stop or even to turn around a repossession order. And it is only a specialist like yourself, people who are able to think outside of the system, outside of the box, to be able to push back a repossession order and to help people out of repossession. And I think there's also an issue there in repossessions, that you've got access to people who assist your clients in moving out of their property without the fear of a repossession order, because the repossession order is quite draconian, isn't it? You get the order, and in certain cases, like you said, in stealth, the banks are aggressive. They can communicate with the local court bailiffs to have you evicted and removed from the property very swiftly, even if the date of the order of eviction is set for maybe 2 or 3 weeks. They could quite easily take the application to a lower court, so the county court, and give it to a high court bailiff, who will come around literally and evict you from the property within no time. So you've got access to organizations that can help in the transition if you know you're going to lose your property, to negotiate with the bank, but move out in a smooth way to alternative accommodation. Is that right? Is that correct, Lakhi Singh, or am I wrong by really saying?
Well, I mean, because we work in this sector, we try not to work on trying to get people accommodated. We try and make sure that they don't end up losing their property. So we would use all the Let's just say legally.
Okay, Lakhi, we're coming to the end of today. I'm sorry, we're going to have to keep it there. A charred man on YouTube says, great discussion. He's liking and he's learning and he's listening. So Lakhi Singh, the property fixer, super guy, the mover, the shooker, the fluker, the swift, the grease, the man who makes the wheels turn in the square mile of London. We're having to say goodbye. I'm going to see you tomorrow. We're going to have the famous VIP, Mr. Johal on tomorrow. So that's Ninder Singh Johal, the gentleman who's famous for his Punjabi MC mix songs and his production work. Again, we'll see you at 8 a.m. to 9 a.m. in the morning, Lakhi Singh. Thank you so much for your time. Speak to you tomorrow morning, sir.